Until tomorrow, we'll see.
What is your last name? Jeffrey. Jeffrey,
Page 16.
thanks. Okay, Ms. Jeffrey, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On August 31st, 2024, law enforcement officers observed the defendant's vehicle run a red light at the intersection of Washington Avenue and Houston Avenue, which is a public road in Harris County, Texas. A traffic stop was initiated. The law enforcement officer made contact with the defendant driver. The law enforcement officer observed a strong odor of an alcoholic beverage, bloodshot red eyes, and slurred speech. The defendant stated that she was coming from a bar and got lost and was going home. The defendant stated that she did not have much to drink. The law enforcement officer had the defendant step out and observe the defendant to have difficulty exiting her vehicle and poor balance. The defendant stated that she drank 1 tequila sunrise. Standard field sobriety tests were administered and the officer observed 6 out of 6 clues for the horizontal gaze test. 4 out of 8 clues for a walking turn and 2 out of 4 clues for one leg stand. The defendant rated her intoxication as a 1 out of 10. The defendant was read DIC and consented to a breath test. The results came back 0.106 and 0.104. The defendant was identified with her Texas driver's license.
Okay. Ms. Jeffrey, I'm going to find that there's probable cause to go forward with your case. So you do or do not have a Texas driver license? Do you have valid liability insurance in your name? Okay, you're on felony probation. Now you've picked up a new case. Do you want to go to prison? You're begging for it. You know, you're on a deferred for a 1 to 4. So you're looking at 2 to 10 in the penitentiary. You picking up this case, they can revoke your probation upstairs and put you in prison for 10 years flat. That's what you're looking at now. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm telling you now, man, I'm going to test you like crazy. The first instance you show me that you cannot control yourself, I'm going to control you, and I'm telling you, I will put you in jail, make your bond sky high. Do you understand?
And Your Honor, as a condition of her bond upstairs, the court is going to be ordering an interlock in the interim while her probation issue
Okay.
plays out.
We'll do the same thing, you know, just out of an abundance of caution as well. From here on forth, you're not allowed to drive any vehicle that doesn't have an ignition interlock. I'll give you a week to put it on. If I find that you drive a vehicle that doesn't have an interlock, at that point, I'm going to lose my shice and I'm really going to make your bond high. Do you understand? Yes, we still don't have pretrial. It sucks. No pretrial again, huh?
No, I just sent it email.
Okay.
Judge, we're heading upstairs to a felony court next, so we'll get her to sign those pre-trial bond conditions.
She's
and
gonna
I
have
can
to wait a
send-
while just because.
Right, I can send her back down.
Does she have court upstairs now?
Yes, Your Honor.
Okay.
Get her to come back down and sign them here as well, Judge. If that's all right.
You want to take her now?
Yes, Judge, I was going to. We're gonna
Okay.
get a reset.
We,
We'll wait on them.
right. You have to come back to sign your conditions. If you don't, I will issue a warrant for your arrest. So just make a note that we need to see her back at some point. If you don't, I mean, we're done here by 12:30. You got to be back before then at some point to sign your conditions.
Yes, Judge.
Okay, all right. So, yeah, I trust you, Val. So, all right, we're gonna be signing a reset and then we'll see you here momentarily.
Okay.
Okay. Good morning, Ms. Martinez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On September 1st, 2024, an officer was dispatched to a major crash involving 4 vehicles on West Harmon Road in Harris County, Texas. A captain with the Harris County Fire Department who responded to the scene observed the defendant to be the driver and the sole occupant of the vehicle. The witness Also observed the defendant sitting behind the wheel. The defendant then got out of the vehicle and began urinating in public. The officer observed a strong odor of an alcoholic beverage, watery, bloodshot eyes, and slurred speech. The defendant was disoriented, swaying, staggering, stumbling while standing, using the vehicle for support while standing, and was throwing up the entire time. The defendant admitted to drinking a bottle of liquor but did not specify what type. The officer observed a completely empty 23.5 ounce bottle of melon sour, which had 13.9% of alcohol on the floor of the vehicle, and a bottle of
Mad Dog 2020.
bottle of 2020 with a slight amount of liquid left in the bottle.
So are you telling me that he's drinking while he's driving?
Standard field sobriety tests were conducted. The defendant was unable to keep his head straight and his eyes open to complete the HGN. For the walk-in turn, the officer observed 8 out of 8 clues and 4 out of 4 clues for the one-leg stand. The defendant was vomiting throughout the entire interaction and inside of the patrol car. The officer did not read the DIC due to the defendant's level of intoxication and his unwillingness to cooperate. Blood search warrant.
Mr. Martinez, you're lucky that in the state that you were, you didn't kill someone. I would hope that you recognize it's elementary that you're not supposed to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason whatsoever. You will be signing an affidavit. This is a promise that you're making to me, that you are not to drive for any reason. I don't care if there's a burning building with 15 cats that you have to save or children. If I find that you drive, I will have a contempt hearing. You'll be facing a minimum of 6 months in jail every time you drive, because I can hold you in contempt and slap you with 180 days. Every time you drive will be an offense in and of itself. As much as I love Joe, I don't give a rat's behind who you are. You get into a car and drive, I'm going to let loose. Do you understand? And the other thing that you need to understand, that when you get charged with the open container and they allege it in your information, it's a minimum of 5 days in jail to any sentence that you do. 5 days flat. No 2 for 1, no 3 for 1. Do you understand? You know that, Mr. Martinez, what you do now will affect you for the next 40 years. Right before I came here, I was watching a video of another judge where there was a young man, same age as you, pleading guilty to 10 years in prison because he had killed someone on the road while driving. And you know what he was asking the judge? Judge, can you please let me out so I can get my affairs in order? You know what the judge said? Gave him a big, fat, middle, you know what? I'm going to tell you now, if I find that you consume alcohol for any reason, I'm going to lock you up and I will put you in a rehab facility myself. Do you understand, sir? And so as it stands, no alcohol, no drugs, random urinalysis, no driving. What's he doing now in life?
Judge, he did have a valid license and insurance at the time.
Yeah.
He's just working right now.
Okay, what do you do in life right now?
I work in a company of sheet metal, duct work.
Did you graduate from high school?
Yes, I did. Yes, I did. Your Honor.
I'm counting on you to stay in contact with Joe. I don't want any more issues from you. If I find any one thing, I'm just gonna lock you up and I'm gonna throw away the key. That's it. You don't drive whatsoever. I really hope you take this to heart. If you drove here, you can't drive home. I don't care what's going on in your life. Do not drive. Okay, Joe.
Yes, sir. Thank you,
All right,
guys. Come on up.
Have a seat in the chair, please.
Come on up, sir. It's okay. Wrestle.
RESSEL.
Come on up, sir. Mr. Russell, you speak English, sir?
Yes.
Sir, you're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine on that charge. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 3rd, 2024, in full uniform in a marked patrol vehicle, an officer was dispatched to a disturbance call at a Taco Bell in Harris County, Texas. The complainant, a manager, stated that after the defendant purchased a cup of soda and sat inside the lobby, the defendant began to harass other people inside of the restaurant. He was later seen washing his undergarments and clothing inside of the bathroom sink. The complainant stated that she asked the defendant to leave the business several times. However, the defendant yelled at the complainant and stated that he was not leaving. The complainant stated that she would like to press charges if the defendant refused to leave. Officers approached the defendant and informed him that the business did not want him on the premises any longer and that he had to leave or that he would be going to jail. The defendant stated that the location is public, so he was allowed to be there. The officers gave the defendant numerous opportunities to leave the premises, but he continued to yell and was actively refusing to leave. After multiple refusals, officers then lawfully ordered the defendant to stand and put his hands behind his back. The defendant again refused. The officers then notified the defendant that at the time, if he continued to ignore the orders, he would be subject to being tasered. The defendant continued to yell and tucked his arms close to his body in order to avoid being handcuffed. The officers continued to try and get his hands behind his back with force, but were unable to do so. The officer then told the defendant that if he continued to resist, he was going to be tased. The officer then ordered the defendant to put his hands behind his back again. The defendant continued to resist. The defendant was drive stunned 6 times, but still refused to put his hands behind his back.
You said they tased him 6 times? Is that what you said? Wow.
With the arrival and the help of another officer, officers were able to get the defendant detained.
So what I see on July 4th, he picks up an interference in this criminal trespass on this case. I guess he gets out. With us, you just take off. We issue the warrant, right? He doesn't come for the arraignment. And then he picks now up an evading arrest. So what happened on that case now?
That one on
I'm not happy with you, Mr. Russell.
On July 17, 2024, an officer was dispatched to an unrelated call located at 3125 South Loop West in Houston, Harris County, Texas. While at this location, an officer identified the defendant by sight and sound from previous encounters. The officers began a consensual encounter with the defendant who stated that he missed his court date. The officers then ran the defendant's information and learned that he had an outstanding warrant in Harris County for interference with public duties. The officers informed him of his outstanding warrant and the defendant attempted to flee on foot, running into a moving lane of traffic on the southbound lane of Main Street. The defendant ran for approximately 15 feet. The officers were able to catch the defendant and he was transported and booked without further incident.
But he ran on the main street. Are you trying to kill yourself? Are you really trying to kill yourself? You know what happens when you run on a major thoroughfare like that? You become Swiss cheese. Mr. Russell, I'm going to find that there's probable cause to go forward on all of your cases. And I'm going to tell you what now. I'm not down with you getting 3 PR bonds in a row and then you pick up 3 cases. Guess what happens? Guess. I'm taking you in. That's what's going to happen. Goes with you. Don't send him down. Can you please appoint him a lawyer? Good morning, sir. Do you have a lawyer today?
Yes, sir.
Tell me what you're doing about that.
Yes, sir.
Tell me what you're doing about that.
I'm trying to hire one, but my finances just won't allow me right now. So I was gonna ask you, can I get a corner point?
Why won't your finances allow you to do this?
And the bond I had to make and just my bills and
Your
stuff.
bond was $100 and we gave you a free bond.
I actually
So
had,
you didn't make any.
another charge. I had an out of county warrant that I had to bond out on.
Uh-oh. Did you pick up a new case?
No, sir, it was an
Uh-oh.
old charge.
Uh-oh. Murillo. Can you run his NCIC, please? Murillo. Did he pick up a new case? Please. He says he had to make an out-of-county bond. Please. Since 2015, you've had a burglary of a habitation, assault of a family member, unlawful restraint, terroristic threat, retaliation, violation of protective order, fraud, 5 items or less, interference, credit card abuse, and now you have a possession case. How many court-appointed lawyers have you had on all of those cases?
More hard than 120, sir.
How, you're not answering my question.
I'm not sure on the exact number.
Judge, the new charges, possession of marijuana, of Montgomery County on, August 30th, 2021.
You picked up a new case while you're on bond for this case, right?
Yes, sir.
Guess what happens now? That's right. It goes with you. I'll appoint your lawyer now.
Mr. Savano, Your Honor.
You know, Mr. Sabalos, you are a very, very, very dangerous person. You are at what they would call hell on wheels. And I'm going to tell you something that since 2021, unlawful carrying of a weapon, terroristic threat, unlawful carrying of a weapon, possession of a controlled substance, FSGI, evading arrest, FSGI, aggravated assault of a family member. And then you get on a second degree possession. Is it a first degree or is it a second degree? You get on deferred for possession of a controlled substance with intent to deliver 4 to 200 grams, which is a first degree felony, 5 to life case. While you're on probation, you pick up a DWI in June of this year. A month later, you DWI. If you want to kill yourself, go right ahead. But I am not going to let you kill people of Harris County. Do you understand? I will not take anything here, and I'm going to set both of your cases for trial. I'm done with this, and I'm going to do everything in my power to protect Harris County. Do you understand? And from this day forward, anytime you pick up cases, we will be doing the same thing. I don't know what's going to happen to you upstairs, but on both of these cases, I will set your cases for trial. And if you are found guilty, into a rehab and patient, into a dual diagnosis residential facility, you will go. Do you understand?
Yes, sir.
If you want to kill yourself, have a great time doing it. Just don't bring everybody else down with you because they have a right to live as well. Do you understand?
Yes, sir.
All right. I'm setting this case for a TRAS now because I want you evaluated to see what kind of facility they deem that is appropriate for you. And that's what we're going to do. Because I'm not going to let you, I don't want that blood on my hands that you're going to kill someone in Harris County. I will not let you do it. Carl.
Hey, Joe.
Hey, bud.
How you doing?